Welcome to CAM Radio, an Ahead of the Curve initiative by Cyril Mangaldas, bringing you every Friday the latest in legal and policy. Stay tuned. Enjoy listening.
So this is a watershed moment in Indian criminal law jurisprudence, and it's also a very important moment for us as citizens of this country and as beneficiaries of the rule of law. We as Cyril Mangaldas have always been very curious and attentive to important topics and developments that affect us and affect our clients. And we try to then quickly equip ourselves to service the needs that inevitably arise from developments such as this. This is one such moment. I see in the coming months and years, there is going to be a massive surge in the need for specialized services to deal with what is coming, both from the likes of law firms like us, who typically are a bit more kind of civil lawish, corporate-ish, and generally kind of we try to outsource a little bit of our criminal law work, but I think that has to change. And I think also external counsel like Amit and some of the counsels here as well. So I think this is going to result in a paradigm shift in the practice of criminal law itself. CAM as a law firm is a non-political firm, and we always stay clear and far away from anything political or any kind of political controversy. So whilst today's topic is political and has political overtones, as we know, everybody who reads the newspapers knows that this has political overtones, but we are going to stick to the professional and the intellectual and see how it has a practical implication. As you can see, even the caption of the session is how does it affect corporate India, and also how does it affect us as citizens. Now, we are not here to debate whether these laws should have been passed or not. They already are passed and they're effective. They're already here. Good, bad, ugly, whatever it is now upon us. So first part is just kind of what just happened. What are these laws and what is the general discourse on this just now, and a few salient features. So every democratic state, right down from time immemorial, every Raja in his heart of hearts, howsoever bad or good the Raja is, somewhere in his heart he wants to do Nyaya. He wants to do justice for his citizen. We should not presume that the Raja does not want to do Nyaya. You may question the modality of doing it, you may question how some of it comes out, but deep in the heart, the very nature of the state, justice is one of the things that you deliver. So I think in this also, and that was part of the explanation that was given, that this is not about dand or punishment, but this is about Nyaya. I can take that at face value. And personally, I am not attributing bad intent on this, or this law was just a massive conspiracy to put everybody in jail. I don't think so. It may happen that way, but I don't think the intent was to sort of create just filler jails. I don't think any state functions like that, particularly in a democracy when you want to get re-elected. Now, India has a historical bad reputation on Tariq pe Tariq. I think we are notorious in the world for the delays in our judicial system, delays not only in the civil side but also on the criminal side. There are the visuals of somebody going into a jail like a young adult and coming out like an old man, and those kind of visuals are kind of drive a lot of our conversation. 75% of 45 million of our cases that are pending are criminal law cases, and around 6 lakh people in jail, of which 75% are under trials. So that with that kind of background, the fact that something needed to be done, I can understand that. So what are the two ideas that were found? The two ideas that were found were, if I can simplify it, is indigenize and decolonize the thinking and add a dose of technology and modernity. See, these two ideas would be perhaps the central pivots around which we will solve this problem. Now, both ideas are prima facie quite unexceptionable, and there is power in both these ideas. But then what is the narrative just now? The narrative is that except for the name, which is now in Hindi, there is not too much of decolonization that has happened. 95%, some say even 99% is the same stuff. Some have called it really a cut and paste job. So this kind of narrative, now I'm not sitting in judgment and assessing whether this narrative is right or wrong. This is the narrative. This we're seeing it on social media, we're seeing it in print media, we're seeing it in public conversations. Then there is a lot of criticism on the process. Nobody was consulted. You consulted the wrong people. You talked to a lot of academic professors and only one practitioner. Why don't you talk to the real people before you do this? Law Commission kya kar raha tha? All those conversations are sort of going on, but again, it is what it is. And some amendments could have done the job. Why did you have to replace the whole thing? So at the end of it, I think what we will see is that the new law looks very similar to the old law, but there are some hidden bombs which we will talk about. And you have to search. Macaulay zinda hai. And kam se kam Macaulay ka bhoot to zinda hai. Ghum raha hai isme. They say the rose by any name smells as sweet. But this is a little bit like our penchant for changing road names. The road is the same every few years, the road ka name changes. And it's like sometimes an English movie with a Hindi name, where like Gone with the Wind could be Hawa ke Saath, or 10 Commandments is Das Adesh. But the movie is the same, exactly the same, the title, everything is in English. So what are these three new acts? The Indian Penal Code, which is replaced. Now, I believe there's a judgment which allows me to call it by the short form, so I'm going to just call it BNS. The Indian Penal Code 1860 has been now replaced by BNS. It consists of 356 sections against 511 at present. 175 sections have been changed, 20 new offenses have been added, and 19 sections have been deleted. The CRPC, which has been replaced by the BNSS, will have 531 sections as against the earlier 448 sections, while 9 sections have been added, 14 sections have been deleted. Now this is not a colonization thing because CRPC was an Indian law 1973. But whatever it is, they are all clubbed together. And the Indian Evidence Act 1872, replaced by the BSA, which has 170 sections as against earlier 167 sections, and 23 sections have been changed. So this is the lead up. This is where we have now landed up with the new rule book. And still the public commentary it's evolving as we speak. It is the hottest topic. Comments include not necessary. The international media loves to bash India and loves to bash Modi, so they will say, it is something which is anti-people, the democratic credentials of this are. So I always discount a lot of what the biased international media says. But that aside, I mean, it does carry around in the world. There's equally another narrative says, great move, this is the best thing that happened. It may be old wine in new bottle, but it's great. Oh no, we have to relearn our law all over again. Ease of doing business just took a massive blow. Arrears will increase by 30-40%. 2 systems in parallel, are we kidding? Why the Hindi title? And why Bharat? Why not India? So these sort of conversations are going on. Now, just a few quick points on some of the highlights on the three laws, which will be picked up in more detail in the presentation. So in the BNS or old IPC, some of the things which we'll do a double click on are the definition, some new definition, organized crime, that's a big one, terrorist act, economic offense. These are all new ideas that have been added with very far-reaching implications, and also the manner in which sedition has been played with, increase in punishment on criminal breach of trust, and a few others. Sedition, the treatment is very interesting. I have a sense of a little bit of a romantic regret that 420 gaya. So now how are we going to make the next 420? So that anyway we'll find some new section. On CRPC or BNSS, this law has had the most change. The biggest change, and I think well-intentioned, but I have a lot of questions about how it's going to play out, is on the electronic mode of proceedings and the digital stuff. It's an idea maybe that's a little ahead of time. Theoretically, anything digital, electronic, technological is better because it speeds it up. But how we are going to implement it in a safe manner, in a manner that preserves attorney-client privilege, preserves the integrity of the data, does not result in identity theft, data theft, all of that, are massive questions to be answered. There is the concept of zero FIR, where you can file in one state for an offense in another state. Staggered police custody is a big issue. Anticipatory bail, the provision has been simplified. On the Evidence Act, BSA, the admissibility of electronic records is a massive change, and how we are going to implement it, both from how primary and secondary evidence is led. What are the technicalities about how evidence will be led is a big item. I'm going to pose a bunch of questions, what I call points to ponder. I don't think we are going to find answers today, but these are points on which we need to think about. We will pick up some of these in the panel discussion afterwards, and hopefully as we go through the rest of the conversations, maybe it will provoke some more ideas in you in terms of what could be some of the questions that we should think about as this journey has just started. First question I have is, has this achieved the goal of justice and not punishment? Just let's zoom out and ask ourselves this question: what has it achieved? Second question, are we technologically ready at police stations, courts, and the practicing bar to implement this? What investment in training will need to be made to equip all the stakeholders, including judges and court officials? Unless you're a very technologically savvy judge, you're going to struggle with this. And the court officials. The whole system will have to be retrained. What challenges are going to lie in the dichotomy between pre-1st July and post-1st July? What if your FIR is when are you applying for bail, if you're applying after 1st July? Purana hai, naya hai, all these questions are even unfolding every day today. What constitutional challenges will be faced in the virus of some of these laws, and consequently, are we headed to a long period of litigation? So in the last 10-15 years, there have been so many judgments from the Supreme Court on bail and on so many aspects of criminal jurisprudence. What happens to all those judgments? Because they have not found their way into the new statute. So will they be read into them by the court now? Or will the law have to be amended? Or as what some states are thinking of now, we'll go for state amendments. So some of the states are pretty miffed that they were not consulted. So they're going to go and make their own state amendments. So how are we now? Is this kind of set of chain reaction of kind of legislative competition? In the digital evidence world, how do we protect against identity theft and data fraud? I mean, we just saw what happened 10 days ago, where some server somewhere and the whole world's Microsoft systems came to a standstill. Now, in that kind of world where technology is so advanced and also the dark side of technology is so powerful, how much does it take for an expert hacker or somebody from Russia or China to play with a system and you can create any fiction you want in the technological world. So how are we going to protect against that? How do we know that the data that is in some server, whether it's the NIC server or where the repository is, cannot be tampered with? We know in the physical world, at least, there are physical safeguards. So do we have robust audit procedures, authentication to avoid miscarriage of justice? And the person who is going to be most vulnerable is the IO at that level. He will have the maximum incentive also, because there can be so many ways in which this can be manipulated. How should corporate India prepare itself to protect its directors and officials? And how will multinational companies perceive this from the point of view of ease of doing business, rule of law? And they would have deputed senior executives, either country heads or others. I think they are a terrified lot. Ki kya hoga in terms of how am I going to face this system? How will cross-border criminal investigation work when the rest of the world is not aligned with this system? We've gone far ahead. I'll use a positive tone and say we have gone far ahead. But we've gone so far ahead that there has to be some comity and comparable relativity with some of the other systems. So now we are alone. What is the impact on the advisory community and fiduciaries? So firms like us have to kind of reinvent and relearn as well. Our lawyers will have to learn technology of how are you going to record digital evidence. It's not enough to know the law, you need to know the technology as well. How can this new system be abused to harass innocent people? I think you can have a field day harassing people with this. And we all have at some point, if you're on a board, very often how often it is some frivolous complaint is filed anyway. Now to even easier, you can file some FIR in some remote place and make any allegation against anybody. What is the protection against abuse when you don't even have authentic identification of people? What are the implications of the new definition of organized crime, which Justice Patel and Amit will talk about? What are the implications of the Terrorist Act, the definition of the Terrorist Act under Section 113 of BNS, which includes economic security? How will extradition work? Amit will talk about also how the in absentia trial work. Will it be only for fugitive offenders or even for others? How will forensic and investigation firms need to retrain and equip themselves? For digital trials, do we have technology that is secure and advanced enough to preserve attorney-client privilege in an electronic trial? I may have a client and an attorney and their counsel will have privileged communication, but if it's all over there and it can be hacked, privilege is gone. How do we prove chain of custody in electronic and digital evidence and protect against tampering? There is the overlap between not only the new law, that is the IPC, CRPC, and the 3 new laws, but also there's PMLA, Prevention of Corruption Act, MACOCA, and there are various versions of it in other states. UAPA, how will all that going to be work? Because some of the offenses are identical, but with slightly different consequences. What changes will need to be brought about in the legal education? This will have to start with law colleges. We all learned the last time I formally learned my criminal law was in college. Now the people will have to start all over again and unlearn whatever else they have learned. Then last point is on the zero FIR concept and what does it do to federalism? We all saw last time what happened when CBI officials visited a state in eastern India to sort of complete an investigation. Now it is official. You can file an FIR in one state and it is theoretically possible for a police department in Gujarat or Rajasthan or anywhere to complete an investigation, go across the border to any state and complete that. So federalism has gone to the winds. So with these are just some of the questions. I know we can, if we get into them in detail, we'll be here all night. And as this unfolds, this is going to be a big one. We are, as I said in the beginning, we are on the threshold of a major change, and it's going to affect each one of us as citizens, as practitioners. I hope it all kind of eventually lands up, because India ultimately finds a way of everything, a combination of judiciary reforms, but it must start from a public conversation. And this is one of those public conversations which can create the right atmosphere where some balance is brought to this conversation. I don't think I'm suggesting that we need to go back on these laws. It is what it is, but we need to make it reasonable.